Order, order. We start with questions. The Secretary of State for Justice, Rachael Maskell.
Thank you, Mr. Speaker. Question 1, please.
Thank you, Mr. Speaker. With permission, I'll answer questions 1, 16 and 17 together. Since 2010, crime is down. So too is reoffending, with the overall proven rate of reoffending down from over 31% in 2011-12 to 25% in 2021-22. That means fewer innocent members of the public suffering the misery of falling victim to crime. To go further, we've been rolling out initiatives including a new prison education service, expanded access to incentivise substance-free living wings for drug recovery, plus the groundbreaking guarantee of 12 weeks accommodation post-release to secure that essential period of stability for offenders to turn their lives around.
Rachael Maskell.
Thank you. With the reoffending rate at 25% and for burglary rising to 50%, reoffending is costing us $18 billion and fails to keep us safe. If just a small fraction of that cost could be invested in the probation staff to address the 50,000 lost sickness days and 2,000 people leaving each year, it could be transformative. So will the Justice Secretary back Operation Project, the campaign spearheaded by the Justice Unions, and ensure there is a comprehensive workforce plan to recruit, retain and return the staff needed to prevent reoffending?
Well, the Honourable Lady is absolutely right that we want to drive the reoffending rate down, which is why it's good news that it's down from around 31% in 2010 to 25% now. But we do believe in investing in probation. That's why the baseline is up by $155 million. It's why we've added 4,000 trainees since 2020, and since the time of reunification, it's up by 17%. Probation officers keep society safe, and we will back them all the way.
Paul Howell.
Thank you, Mr. Speaker. I recently raised the issue of social media use in prison, allegedly by one of those responsible for the murder of Jack Woodley, son of my constituency, Zoe McGill. Locally, we've got a campaign against knife crime happening, and at the last working group we discussed deterrence. Zoe would like to understand what consequences were suffered by this individual for posting, but also why he should be wearing a designer T-shirt and looks to be having a cushy life. Prison needs to be seen as a deterrent, and if inmates are having it easy, designer wear, no consequences, how is the deterrent happening? Can I ask the Minister what's being done to address this and make prison the deterrent that it should be?
Thank you, Mr. Speaker. I know the whole House will want to send its deepest sympathies to Zoe McGill following the shocking murder of her son in 2021, which was a dreadful crime for which 10 men were convicted and received life sentences. Social media in prisons is not acceptable, and this content was removed from the social media platform. We've been investing £100 million in prison security and new technology, including X-ray scanners, to tackle the smuggling of contraband mobile phones. Those caught can face loss of privileges, further time in custody, and even a referral to the police and CPS for consideration of further charges.
Time fell.
Thank you very much, Mr. Speaker. I was very grateful for the government's support for my private member's bill last year, limiting Friday releases for vulnerable prisoners. That's an important measure. It's now an act of law, but it's only one of the measures we should be taking to reduce reoffending and help people get back on their feet when they leave prison. The excellent charity Switchback has suggested that at the very minimum people should be leaving prison with access to an ID, an internet-enabled mobile phone, just to get their lives in order so they can access universal credit and other services. I wonder what consideration my right honourable friend has given to those suggestions.
Well, first of all, can I thank my honourable friend and pay tribute to him for the excellent work he's done to successfully champion the limit on Friday prison releases. The changes he called for came into force last November, and they are exceptionally helpful, so he deserves great credit for that. He's also absolutely right to point to the brilliant work of Switchback, who've supported our resettlement work. That work includes the rollout of 12 weeks guaranteed accommodation, resettlement passports as well, which contain precisely the basic information he referred to, such as a prisoner's name, date of birth, national insurance number and release date. And they help prisoners access essential services such as housing, such as healthcare, and they contribute to driving down reoffending, which, as the Honourable Lady for York recognised, is significantly lower than in 2010.
Andy Slaughter.
Thank you very much, Mr. Speaker. The wife of a remand prisoner at Wormwood Scrubs wrote to me recently to say the prison is so cold, prisoners are shaking, prisoners have to choose between work, social time and showering, and food is lacking basic nutrition. I can explore these matters with the Prisons Minister during our joint visit to the Scrubs in a couple of weeks, but would the Secretary of State agree that such conditions are not conducive to rehabilitation?
It is a really important point that we do deprive people of liberty, and sometimes we have to do so on remand, but the conditions must be safe, decent and humane. Of course they must. Austere, yes, but humane too. So commend the honourable gentleman for going to see the scrubs with my right honourable friend, the Minister, and I'll be very interested to hear his views thereafter.
Shadow Minister Ruth Cadbury.
Thank you, Mr. Speaker. We, of course, need to tackle the revolving door of reoffending in our justice system, yet the reoffending rate as a proportion of those leaving prison continues to rise. Whatever the Secretary of State may say, I've heard time and again that the lack of secure housing, the lack of adequate and appropriate healthcare, education, job training and job support means prisoners are being left to fail after they're released. It's the victims of crime who then suffer when ex-prisoners reoffend. So can the Secretary of State therefore announce when the government expects the reoffending rate to go down?
It's important to note, reoffending is down compared to under a Labour government. She shakes her head, but one can have opinions in this House, but not facts. So the reoffending rate in 2010 was around 31%. It's 25% now. That means fewer people falling victim to crime. She refers to accommodation. She's right to refer to accommodation. What she didn't advert to is this government's decision to provide 12 weeks guaranteed accommodation. That didn't happen under a Labour government. And when I went to Luton and Dunstable, I spoke to a probation officer who's done it for 30 years. And do you know what he said? It's the single most effective measure to drive down reoffending. Who did that? Not them, us.
Nigel Mills.
Number 2, please, sir.
Minister.
Thank you, Mr. Speaker. Measures in the sentencing bill will ensure that those who commit the worst crimes will receive the most severe punishment. The bill creates a duty for the court to impose a whole-life order for murders currently subject to a whole-life order starting point and those that involve a sexual or sadistic conduct unless there are exceptional circumstances. And the bill will also ensure that convicted rapists must serve 100% of their custodial term in prison, followed by a licence period.
Nigel Bill.
I thank him for that answer and welcome those measures. I think the two worst cases I've had to deal with as an MP was where the women were brutally murdered by their partners or ex-partners. So what is the government going to do in response to the Clare Wade review to increase sentences for people who commit those awful, vile offences?
Minister.
I thank my honourable friend for his question. He's quite right to raise the issue of domestic homicide. We are determined to take action to protect the victims of domestic abuse and ensure that the appropriate punishments are in place for perpetrators, which is why, following Clare Wade KC's review, we're increasing sentences by introducing statutory aggravating factors for murder, which are preceded by controlling or coercive behaviour, involving overkill or connected with the end of a relationship.
Gregory Campbell.
Would the Minister agree with me that confidence in wider society is often, amongst the judicial system, is often determined by how dangerous offenders are treated? And would he agree with me that it is vital that we get the message out there, both to wider society and those potential offenders, that there is the ultimate price to pay, which is a long sentence in prison for criminal offences such as these?
I thank the honourable gentleman for his question. I agree with those sentiments entirely.
Richard Bergen.
Question number 3, Mr. Speaker.
Thank you, Mr. Speaker. In his excellent report, The Patronising Disposition of Unaccountable Power, Bishop James Jones called for the creation of the Hillsborough Charter for bereaved families, as well as the imposition of a duty of candour on police officers. We agree wholeheartedly. And it's why the government has signed the Charter alongside the CPS, National Police Chiefs Council and others, and imposed a duty of candour on the police. We are also legislating to create a strong, permanent and independent public advocate to speak up for victims and their families and rigorously hold signatories to the Charter to account. We stand ready to discuss what further steps may be necessary.
Richard Bergen.
Thank you, Mr. Speaker. The parents of Zain Bangbola are in the public gallery today. Zain was just 7 when he died following floods 10 years ago this month. The fire brigade detected hydrogen cyanide multiple times. His parents, Kai and Nicole, have been fighting for the truth about their son's death ever since. A duty of candour would have helped them to get it. But in lieu of that, will the government establish an independent panel inquiry with full disclosure so that all the evidence can be reviewed by experts and so we can finally get the truth about what happened to an innocent 7-year-old boy and so that justice can be done?
Justice Secretary.
Well, I'm grateful to the honourable gentleman for raising this deeply upsetting case, and I know the whole House will be thinking of Kai and Nicole as they continue to mourn the loss of Zain. He raises a critically important case. Can I suggest that he and I speak to discuss it and see what further steps can properly be taken in this difficult case?
Shadow Minister Kevin Brandon.
Thank you, Mr. Speaker, and I welcome the meeting that the Secretary of State has just offered. But the problem in general with the government's response is it ought to be centred on the experiences of the families to ensure that they're never repeated and not on the convenience of state bureaucracy. There's nothing in what we've seen so far from the government that goes as far as we believe is necessary, and more importantly, as far as the families believe is necessary to require public authorities to act with candour and transparency. So why is he persisting with a piecemeal approach instead of committing to a clear, compelling and comprehensive duty of candour as proposed in the Hillsborough law?
Justice Secretary.
Well, as I say, the recommendations of Bishop James Jones's report, which we've considered extremely carefully, contain the Charter for Bereaved Families, and it's worth reflecting what paragraph 3 of that says. It requires the public body to approach forms of public scrutiny, including public inquiries and inquests, with candour, in an open, honest and transparent way, making full disclosure of relevant documents, materials and facts. Taken together with powers that exist under the Inquiries Act, potentially criminal culpability, there's misconduct in a public office, perverting the course of justice, but of course we will keep this under review. We want to ensure that public bodies do what they should, act transparently, and we will always consider what further steps can be taken.
Rachael Longy.
Question number 4, please, Mr. Speaker.
Thank you, Mr. Speaker. With permission, I'll answer questions 4, 7 and 10 together. In September 2020, a public inquiry was set up into the failings associated with the Post Office Horizon IT system, and it is expected to report back later this year. In addition, over £160 million has already been paid out in compensation across 3 schemes. However, in their December 2023 letter, the Independent Horizon Compensation Advisory Board expressed its concerns that the pace of exonerations was too slow, not least because evidence had been lost and many were simply too traumatised to come forward. That's why the Prime Minister has decided to bring forward legislation to quash the relevant convictions, and DBT will be announcing details shortly. These wholly exceptional circumstances have led to this wholly exceptional course.
Rachael Longy.
Thank you, Mr. Speaker. So, whilst I do welcome, of course, the government's commitment to quash the convictions of the wrongful convictions of sub-postmasters caught up in the Horizon scandal, I also do recognise that this is a complex area of law and could even raise constitutional issues. But does my right honourable friend agree with me that, given that some sub-postmasters have been suffering for an extremely long time, it is right that any legislation does in fact deal with these issues very swiftly and avoids any further delays?
Well, I thank my honourable friend for the careful and thoughtful way in which he addresses this really significant issue. The judiciary and courts have dealt swiftly with the cases before them, but the scale and circumstances of the prosecution failure means that this demands an unprecedented response, and that's why the Prime Minister announced this major step forward in response to the Horizon scandal. We are keen to ensure that the legislation achieves its goal of bringing prompt justice to all of those who were wrongfully convicted, followed by rapid financial redress. It's not right that wholly innocent people could potentially go to their graves with the mark of and stigma of conviction hanging over them.
Gavin Newlands.
Thank you very much, Mr. Speaker. Every day we hear further revelations about the Post Office, and today's shocking, well, what should be shocking, BBC story states that the 2016 Swift Review noted the Post Office had always known about the balancing transaction capability of Horizon. Moreover, that the government knew in 2016 that a Deloitte investigation was underway in all Horizon transactions, and that this investigation was suddenly halted after postmasters began legal action. So will he confirm whether the MOJ were aware of this? And does he believe that apparent non-disclosure to the inquiry is a threat to judicial freedom and independence?
So in 2020, coming up for 4 years ago now, an independent inquiry was set up under Mr. Justice Wynne Williams. That is expected to report later this year, and that is going into properly exhaustive details about who knew what and when. We are absolutely clear there has been an egregious failure of prosecution conduct, frankly one which brings shame on those involved, and it's absolutely right that that inquiry should get to the bottom of what took place and who knew what and when.
Thank you, Mr. Speaker. The current Chief Executive of the Post Office gave evidence at the Business and Trade Committee last month that despite various audits and investigations, we still don't know the full scope of the money overclaimed through Horizon, nor where it went to. Even their auditors are unable to give a firm figure. The postmasters, like my constituent Roger, have suffered incredible stress and worry, as well as significant financial loss, and the prospect of getting to the truth of these figures still seems far off. So will he commit to working with the Secretary of State for Business and Trade and set out a timetable updating the House on how much the Post Office took, what they did with the money, so that constituents like mine can start to get the answers and the justice that they deserve?
Well, look, my heart goes out to Roger and people like him. I have constituents who are affected, and I'm sure everyone in this House has constituents affected. And we are basically a fair-minded nation, and this is why it really strikes us to the core. So she asks me to liaise with DBT. Of course, the MOJ will do everything it properly can. DBT is leading on this, but it's also worth reflecting that £160 million has already been paid out across the three schemes, and a very important and swift and robust approach of £600,000 for those who have their convictions quashed. That is the right approach. It is exceptional, but these are exceptional circumstances.
Chair of the Select Committee, Sir Robert Neal.
Thank you, Mr. Speaker. My right honourable and learned friend will know that only last week the Court of Appeal Criminal Division, presided over by the Lady Chief Justice, quashed in bulk a number of Horizon appeals on the basis of about a half-an-hour hearing. When the cases get to the courts, they can deal with them swiftly. Would my right honourable and learned friend agree that in framing any legislation, because of the constitutional implications, it's important that we bear in mind that the failures are failures of a prosecutor in doing their duty, or perhaps failures of the state in coming to the aid of victims, but they are not failures of the court, who always acted entirely properly on the material that was put before them by the parties at the time. It's the failure of the parties, not the failure of the courts, that we must do.
Well, as always, my honourable friend gets absolutely to the heart of it. This was a failure of the Post Office, an emanation of the state, if you like, and it is the duty of the state to put it right. The courts have approached this entirely properly. The Post Office failed to discharge the solemn obligations which exist on any prosecutor. That is to act fairly, to comply with their obligations under Section 3 of the CPIA, which is to disclose material which might reasonably be considered capable of undermining the case of the prosecution or assisting the case of the defence. When I was prosecuting, the first rule is you do not seek a conviction at all costs. That is an important principle which the Post Office failed to appreciate.
SNP spokesperson Chris Stevens.
Thank you, Mr. Speaker. Whistleblowers have come forward to provide information that Fujitsu was given an additional contract by the Post Office in 2015 to re-platform transaction data that was previously held on an external storage system that was considered to be the gold standard. It was replaced with a system that would make it virtually impossible to investigate branch transactions in a forensic audit. So does the Justice Secretary share our concern that this decision effectively destroyed evidence, preventing exactly the sort of audit trail that would exonerate those postmasters convicted?
Secretary.
Well, look, the specific points he raised are a matter of detail which I think DBT are better placed to answer. But there are just two things I'd say. First, as a matter of sacred principle for a prosecutor, if material comes into a prosecutor's possession which might be considered capable of undermining the case of the prosecution, that should be disclosed to the defence. And one of the things that is falling to be considered by Sir Wyn Williams' inquiry is precisely that. What did the Post Office know? When did they know it? And what did they do with the material before it? And those are the answers which we, across this House, want to get to the bottom of.
Well, let's just stop there.
Number 5, please, Mr. Speaker.
Minister.
Thank you, Mr. Speaker. It's a pleasure to respond to, I think, my first question from the honourable gentleman since his election to this House. As part of the government's antisocial behaviour action plan, community payback teams are working in partnership with 11 local authorities to rapidly clean up antisocial behaviour in the community. The pilots started in July 2023 and are ongoing, and we are in the process of analysing the outcomes. Initial observations point to these pilots having been successful, with thousands of hours of reparative work having been done by hundreds of people on probation within 48 hours of notification from the local authority, allowing the public able to see justice done.
Let's just stop there.
Thank you, Mr. Speaker. These rapid deployment community payback scheme pilots were supposed to pave the way to an accelerated rollout of exactly the kind of swift, transparent restorative justice victims of crime in my constituency are desperate to see. But unfortunately, I understand that of a planned 20,000 hours of work, only 2,000 might have been delivered by the pilots.
Can the Minister reveal if this was in fact the case, and if so, what can be learned by the barriers that this clearly is showing were there for success?
Minister.
I'm grateful to the honourable gentleman, but the clue to this is in the word pilot. This is being carried out in 11 areas and in the space of 3 months in the run-up to Christmas. 175 people completed around 2,000 hours of unpaid work. That's just in 3 months in 11 areas. We're analysing the outcomes of those pilots, and I look forward, based on what that analysis says, to exploring how we can roll this out more widely across the country.
Murray Rimmer.
Question number 6, Mr. Speaker.
Minister.
Thank you very much, Mr. Speaker, and with your permission, sir, I'll answer questions 6 and 12 together. And I'm grateful to the Honourable Lady for her question. We know that activities such as education and training can help give prisoners skills they need to get a job on release, reducing the likelihood of reoffending. That's why we've launched our new national regime model last month for prisons. It sets out core expectations for regime delivery, so prisons are getting the most out of the working day and are aiding the rehabilitation of prisoners. And of course, we're also seeing improved staffing numbers to facilitate those regimes.
Murray Rimmer.
Thank you, Mr. Speaker. Reoffending 18 billion a year, not just the financial cost, it's the impact on society, generally speaking, not just the individual. Some young prisoners are still only getting 1 hour out of their prison cells, and this is no time. There's no time for rehabilitation. 1 hour, perhaps a little exercise. So that isn't doing it. How confident you are that all young prisoners will get this training and re-education, as the Minister has outlined? And when do you see a time when we get all young prisoners, if they have to be in prison, get proper rehabilitation and the support that they need when they come out of prison to get a home, to have somewhere to stay, to go into further training when they come out? Could you please give me some reassurance that there's better times coming, not just for the young offender, but for society as a whole?
Well, I'm grateful to the Honourable Lady, and she knows I have a huge amount of respect for her in this House, and she raises an extremely important point. We've heard from the Lord Chancellor that reoffending rates since 2010 have come down from 31% to 25%, so we're making progress, but we want to drive them down further. And she's also right to highlight the importance of purposeful activity leading to the opportunity for employment, for accommodation and so on release as central to the opportunity for those prisoners to rehabilitate themselves. We've seen in our youth estate significant progress made. She's right, we need to go further, and she's talked about young prisoners. The national regime model, which we launched in January, we believe will go a long way to doing that. But central to doing this are the additional staff we've recruited into HMPPS, which enable that regime to be put in place. But she's absolutely right to highlight this.
Claire Anderson.
Thank you, Mr. Speaker. I welcome the acknowledgement from the Minister that more education in prisons means cutting the reoffending rate, that clear link to crime. And I welcome the national regime model. I'll be interested to see how that plays out, because I've seen chronic staff shortages and sickness absence, in particular, at prisons like HMP Wandsworth that I visited, may mean that prisoners are entirely missing out on any education, training and working opportunities. So when will I be able to go back to HMP Wandsworth and see the increase in staff and retention that's needed there? And when will the government get a grip on the prison officer recruitment and retention crisis?
Minister.
Well, I have a lot of respect for the Honourable Lady, but I'm afraid what she's suggesting there doesn't entirely reflect the facts. If we look at 2023 versus 2022, band 3 to 5 prison officers, there are over 1,400 more prison officers there. That's an increase of 6.7%. Sick rates for HMPPS are down over the past year. And we're also seeing, for example, last year, HMPPS, 12,500, just over 12,500 joining, whereas 7,500 left. That is, again, reflecting an increase. We are investing in our prison officers. We're increasing the number of our prison officers. And we're seeing that reflected in retention. I want to pay tribute to the work they do. We should be talking them up, not talking it down.
Butler.
Thank you, Mr. Speaker. On exactly that point, I'm encouraged by the comments of my right honourable friend about the number of additional prison officers who've been recruited. I've seen many of them and the fantastic work they do, both at HMP Aylesbury and across the prison estate. Can the Minister say a little bit more, though, about how we can ensure that we retain those once they have been trained, once they go onto the wings, because this is an incredibly important career. It is key to reducing reoffending, and these prison officers deserve credit and the support of everybody in this House.
Well, I'm grateful to my honourable friend. He's absolutely right about not just the importance of recruiting new prison officers, but retaining experienced prison officers in our prisons. That's why the pay deal done last year with HMPPS staff, I think, was hugely important, recognising the important work that prison officers do day in, day out. And that's also reflected in the fact that the leaving rate for prison officers is down 2023 compared to where it was in 2022. But there is more to do, and we'll continue to do it.
Shadow Justice Secretary Shabana Mahmood.
Thank you, Mr. Speaker. Prisoners are spending up to 23 hours a day locked up in their cells as a direct result of overcrowding and the prison's capacity crisis caused by this government. But I do hear that congratulations are in order following an announcement last month. Not for the government actually delivering any of the new prisons that they promised, not even for getting spades in the ground, but for submitting yet another planning application for the Leicestershire prison, which the Levelling Up Secretary has already ruled on once. So isn't it about time that the Minister renames the New Prisons Programme the No Prisons Programme?
Well, I'm grateful to the Shadow Justice Secretary for that. For a moment I thought she was referring to her own party's record when in government. 7,500 prison places in 3 Titan prisons due to be built, failed, not built, whereas we are committed to building 6 new modern prisons. 2 have been built, one's being built at the moment, and 2 have got planning permission.
Mr. Speaker, while prisoners are serving their sentence, they are not being allowed to leave their cell. But ironically, this government is also releasing some of them early. Despite a multitude of letters, questions, and even a point-blank request from the Justice Committee, the government is refusing to tell us how many prisoners are being released early and from where. The public has a right to know, and Parliament has a right to know. So will the Minister finally come clean on how their early release scheme has been used so far? And if not, can he tell the House what does he have to hide?
I'm grateful to the Shadow Justice Secretary. As she will know, my right honourable friend, the Lord Chancellor, has made clear that in line with other statistics, for example, death in custody statistics, we will publish these figures on an annual basis.
James Gray.
Mr. Speaker, I'm sure my honourable friend will agree with me that rehabilitation offenders can be greatly assisted by activity and work outdoors, in particular on farms and horticultural establishments. Can the Minister reassure me that he is committed to increasing the quantity of work available outdoors? And let me know what has happened to the prison estate in recent years.
Well, I'm grateful to my honourable friend. He's absolutely right to highlight the importance of a range of purposeful activity for those in prison, from skills, from industrial work, in workshops, but also to outside work. And indeed, one very good example of that, which I saw mentioned just recently on, of all things, ITV Racing, was about getting farriers and those working in the equine world into prisons, into Solihull prison, I think it was, to teach prisoners about job opportunities in the equine world as well. There's a whole range of opportunities out there. It's important that they are available to those in our custody.
Number 8, please, Mr. Speaker.
Thank you, Mr. Speaker. We remain committed to reducing the Crown Court outstanding caseload and have introduced a range of measures to achieve the same. We funded over 100,000 sitting days last financial year and plan to deliver the same again this year. We've recruited over 1,000 judges over all jurisdictions and plan to do the same again this year. And thanks to the intervention of the Lord Chancellor, he's secured £220 million for essential modernisation and repair work over the next 2 years. And as well as retaining Nightingale courts, the investment will also see 58 new courtrooms.
Nick Smith.
Mr. Speaker, the facts are that the Crown Courts now have a backlog of over 65,000 cases. If this isn't bad enough, experts say the court's capacity to deal with processing cases won't keep pace with demand. So does the Minister agree that this leads to too many victims, unfortunately, giving up on our justice system?
Minister.
Thank you, Mr. Speaker. No, I don't accept that it means we're giving up on this system. As we're saying, this government continues to invest in every single lever that we can pull to increase capacity in our criminal justice system. And in fact, what we're seeing, given that the additional work the judiciary are doing, we're actually seeing the disposal rate in our Crown Courts is up. And so we're seeing record levels of disposals. So we will start to see the criminal justice system heal, because we are still recovering from COVID and the Criminal Bar Association strike.
Shadow Minister Alex Cunningham.
Thank you very much, Mr. Speaker. Rape and serious sexual assault cases have increased to 10.3% of all Crown Court cases, and with nearly 10,000 of them, they make up 1 in 7 of the backlog. The average wait time for a trial after charge has risen to 18 months. We also know from the Criminal Bar Association there's been a tenfold increase in adjourned cases due to the fall in the number of RASO prosecution or defence barristers, with the CPS now employing King's Counsel to fill the gaps. Add to that the many legal aid deserts due to the shortage of solicitors, and we have a major staffing crisis across the criminal justice system. How is it going to be fixed?
Minister.
Mr. Speaker, first of all, can I say that it is not true. The figure that the Honourable Gentleman quoted for the average time for a RASO case is simply not true. And the government has continued to invest in ensuring that RASO cases are brought forward. Listing is a matter for the judiciary, and they take great care to ensure that vulnerable victims are dealt with expeditiously. In addition to that, we continue to invest in the legal aid system, and the Lord Chancellor recently increased the fees to ensure that there were people able to do RASO cases and Section 28 video recording. And on top of that, Mr. Speaker, we continue to engage with the criminal legal aid review to ensure how we can continue to invest and incentivise criminal defence barristers in the right parts of the system.
Question 9, please, Mr. Speaker.
Justice Secretary.
Thank you, Mr. Speaker. Since 2010, we've ramped up support for victims in 3 main ways. First, we've driven down reoffending from around 31% to 25%, so that fewer suffer the misery of becoming a victim of crime in the first place. Second, we've created new offences like stalking, coercive and controlling behaviour, revenge porn, upskirting, non-fatal strangulation, so that those who betray trust and shatter lives can be held to account. And third, we've quadrupled victims' funding, enabling massive investment in resources such as IDVAs, up from barely existing in 2010 to over 900 today, and we're going further with the groundbreaking Victims and Prisoners Bill 2.
Thank you, Mr. Speaker, and I thank my right honourable friend for all the sterling work that he has just underlined, which is making such a huge difference to victims everywhere. I wanted to raise a particular case raised with me at an advice surgery. After first seeing an ad on the tube, my constituent, a man of very good standing, invested in what turned out to be a fraudulent company to the tune of £93,000. He was clearly a victim of crime, and mercifully his bank reimbursed his life savings after some challenge. So he did get financial restitution, but the whole experience had wider, devastating impacts. Those behind the company were registered in Serbia and, to the best of our knowledge, have never been brought to justice. As my constituent didn't go through the full criminal justice system, can I ask how victims such as he can be supported in cases such as this?
Thank you, Mr. Speaker, and I thank my honourable friend for raising her constituent's case. Look, fraud is a pernicious, it's a cruel crime that can have an appalling impact, as I know from my own experience of prosecuting for the Serious Fraud Office. To support victims in recovering lost funds, the Financial Services and Markets Act 2023 gives the payment systems regulator further power to mandate reimbursement where needed, and I'm glad that took place in her case. But to bring wrongdoers to justice, prosecutors, including the CPS, the FCA, the SFO, regularly cooperate with their international counterparts to make arrests and secure evidence overseas, so that in appropriate cases defendants can be extradited to face trial in the UK. But the other critical point is the Victims Code has been expanded so that people like her constituent can get the support they need. I would invite him, perhaps through the Honourable Lady's good offices, to look at what support is available online.
Very Sherman.
Mr. Speaker, will the Secretary of State be well aware of a new crime that is spreading throughout the north of England, in your constituency, Mr. Speaker, and mine? And that's a group called SSRA. that are actually preying on people who would have cavity wall insulation, and then they get themselves into the legal process, find that the expenses are so high that they have to sell their house. It is an epidemic, and it's rather like, Mr. Speaker, the post office scandal. This is an early warning of a major scandal, and would the Secretary of State agree he would look into this? It's very, very important, especially in the north of England.
Well, can I thank the honourable gentleman for raising this on the floor of the House? He'll understand, I know he well appreciates this. It's not for the Secretary of State to be ordering investigations, but plainly the matters he raised are serious, and that I would invite the police and prosecutors to take all appropriate steps to investigate it if that's what's required.
Kim Jones.
Question number 11, Mr. Speaker.
Minister.
Thank you, Mr. Speaker. Although the Ministry of Justice collates statistics nationally on the principal criminal offence that a perpetrator is prosecuted, convicted or sentenced under, including data on their ethnicity, it does not collate data on whether the crime they committed was part of joint enterprise. So unfortunately, I'm unable to provide the information the Honourable Lady has requested. However, going forward, we are considering whether such data could be collected as part of the Common Platform programme, which aims to provide a single case management system that would enable the sharing of evidence and case information such as this across the criminal justice system.
Jim Johnson.
I welcome the response from the Minister, but the Minister will know that Manchester Metropolitan University have recently carried out some research into the cost of prosecuting under joint enterprise. 250 million for just over 1,000, and an extra 1.2 billion to incarcerate those 1,000s for a year. And I'm sure the Minister will agree with me that those amounts of money are very eye-watering. So will the Minister agree with me that we need to review the doctrine of joint enterprise to ensure that only those who have been responsible for a significant contribution are punished for a crime?
Minister.
Thank you very much, Mr. Speaker. I thank the Honourable Lady for her question. The answer is, of course, that there is a cost to justice. People who are found guilty of crime in the courts of law, based on the evidence presented to the court, have been sentenced, and there is a cost to their incarceration. So simply the cost of incarcerating people could not be the reason why we'd need to review the law.
Beth Windsor.
Question 15, Mr. Speaker.
Minister.
Thank you, Mr. Speaker. The Government is clear that it's in the best interest of the people of Wales for justice to remain a reserved matter. The current arrangement works well and allows Wales to benefit from being part of a larger, world-renowned justice system. Devolving justice to Wales would mean losing those benefits and would be extremely expensive and complex, requiring the duplication of functions.
Beth Windsor.
Thank you, Mr. Speaker. Following the publication of the Independent Commission on the Constitutional Future of Wales last month, the First Minister of Wales confirmed unambiguously that it is the policy of Welsh Government and indeed the Welsh Labour Party to support the devolution of the justice system. And in pursuing the devolution of probation service, he said we have to explore governance, finance and the interface between Welsh and English services. So can I ask the Minister, when will he be meeting the Council General in Wales to discuss the devolution of justice?
Minister.
If the representatives of the Welsh Government wishes to meet with me, I'm more than happy to explain why I believe Wales, being part of the English and Welsh legal system, remains the preferred option for this government. Why would Wales want to leave the most successful legal services system in the world?
Anna McMorran.
Question 18.
Minister.
Thank you very much, Mr. Speaker. With your permission, I'll answer questions 18 and 19 together. It is paramount that victims come forward without fear that their privacy will be violated. That's why we're taking steps through the Victim and Prisoners Bill to create a statutory restriction that limits police requests to third-party material to only that which is necessary and proportionate, and to inform victims why such material is being requested. The Government has also asked the Law Commission to undertake a review on the use of evidence in sexual offence prosecutions, and they are due to report later this year.
Thank you, Mr. Speaker. My constituent had all her counselling records used against her in a harrowing trial that she said was worse than the crime itself. Can the Government therefore confirm
that the bill will be sufficiently amended to ensure medical and social services records are not used against the victim in court. And also, in addition to this, that family courts are not used to perpetuate that abuse in this respect, participating and using the term parental alienation against the victim.
Minister.
Well, I thank the Honourable Lady for her question. I'm really, truly sorry to hear what happened to her constituent. If I could reassure her, I hope, by saying that there will be new regulations published under the Victim and Prisoners Bill that will create a code of practice setting out the principles that the police should apply for all third-party requests, including counselling, therapy, medical notes. The police will be required to complete a new request form that sets out the purpose of and impact of their request. And the CPS also has a robust case file review process to ensure that guidance on necessary and proportionate requests are complied with. I want to make clear to her that the CPS pre-trial therapy guidelines makes crystal clear that victims must not delay therapy for criminal investigation or prosecution.
Jones.
Thank you, Mr. Speaker. Recently, I was able to visit the Gwent Rape Investigation Unit and see what an excellent job the police officers are doing there. But why can the Minister explain why the government thought it was appropriate to boast about the so-called progress of the rape review, whilst the proportion of cases being charged has halved since 2016, and the key advisor quit because of the lack of drive to see outcomes for the victims improve?
Minister.
Well, I have also heard very good reports about the work that the Gwent police are doing, so I'm glad to hear that. I must push back very slightly. Since we launched the end-to-end rape review, we are now prosecuting more rape cases than we were in 2010. Conviction rates are higher. Perpetrators are going to prison for almost 50% longer than they were in 2010. The average sentence has increased from 6.5 years to 9.5 years. And just on the independent advisor to the rape review, I accept the last one went, but we have last week announced the appointment of Professor Katrine Howell, who was a legal academic who pioneered Operation Soteria, which I think every member of this House agrees has transformed the way that police are investigating and prosecuting rape and are leading to better criminal justice outcomes for victims.
Sarah Green.
Question 20, Mr. Speaker.
Minister.
Thank you, Mr. Speaker. Non-disclosure agreements cannot prevent any disclosure that is required or protected by law, nor can they preclude an individual from asserting statutory rights. The courts and judiciary apply the law in relation to NDAs as appropriate in individual cases and, where necessary, determine whether they should be enforceable or not.
Last year, the Legal Services Board stated that incidents of misconduct by lawyers when dealing with non-disclosure agreements are a cause for concern, and that there is a strong case for a strengthened and harmonised regulatory approach. Does the Minister agree that there is a need for stronger regulation in this area? And will he support my honourable friend, the member for Oxford West and Abingdon's bill to end the misuse of non-disclosure agreements in the workplace?
Thank you, Mr. Speaker. I'm more than happy to have a discussion with the Honourable Lady, but my understanding is that the Solicitors Regulation Authority has already published a warning notice reminding solicitors and law firms that potential professional misconduct by a person or firm should be reported to the regulator. If the Honourable Lady believes that there are still gaps in that warning notice or more needs to be done, I'm more than happy to have a meeting.
Come to Topital, Steve Double.
Welcome, number one.
Mr. Speaker, since the last justice questions, I've met with the families of Barnaby Webber, Grace O'Malley Kumar and Ian Coates, who were killed by Valdo Calacane. They deserve answers, and I know that a series of reviews are taking place, including by the Attorney-General, to refer the case to the Court of Appeal, the sentence to the Court of Appeal. We've announced an early legal advice pilot to help families agree child arrangements quickly. I visited Leeds to see how £6 million is being spent to roll out state-of-the-art courtrooms as part of our £220 million investment in the court estate. I've travelled to the USA to meet my counterparts to discuss how Russia can be held financially and legally to account, and I was fitted with a GPS tag, Mr. Speaker, to experience for myself how effective modern technology is in holding offenders and Justice Secretaries to account. A constant physical reminder that debts to society must be repaid, court orders must be observed, and transgressors face the very real risk of the clang of the prison gate. No, I haven't got it on now. No.
Mr. Speaker. As my right honourable friend just mentioned, I'm aware he spent a day wearing a GPS tag, along with Jack Elsom from The Sun. So I wonder if he could outline what he learned from this experience and whether he thinks GPS tags are a robust and effective means of monitoring and punishing low-level offenders. And would he also reveal to the House who else from the lobby is on his list to be tagged?
Just to remind everyone, it's topicals.
Thank you. Well, can I thank the honourable gentleman? Look, there's a serious point here. Our modern GPS tags act as a constant physical reminder that debts to society must be repaid, that breaching a court order will be detected, so that a person who steps over the line, literally as well as metaphorically, and enters an area he's barred from, knows that he's liable to be returned to court and be sent to prison. We could put the entire lobby on tags, alcohol tags, but I think that would deal a fatal blow to the UK drinks industry.
Amy.
Speaker, when I recently visited Cookham Wood Young Offenders Institution, officers told me of the challenges they face. This includes a staffing shortage and shocking recruitment issues. This has led to rising levels of violence. So can the Minister say when they last visited Cookham Wood and why this government continues to be unable to solve these crucial problems?
Secretary.
So I have visited Cookham Wood. I can't remember the precise date, but I think the really important statistic to note is that in the period up to the end of September last year, we recruited an additional 1,400 prison officers. The numbers are going up and the attrition rate is going down. They're holding on because we've introduced things like the new colleague mentor scheme. We've rolled out £100 million in security and so on. We recognise that the safety of our prisons is in large measure down to the quality and the quantity of our staff. We're improving on both counts.
Sir Edward Lee.
There was an interesting debate in the House of Lords last night in which Lord Hoffman confirmed my own understanding that the Court of Human Rights was wrong to impose a Rule 39 injunction to stop flights from Rwanda and that we could safely ignore such an injunction. Will the Secretary of State confirm that that is his understanding of the law? And if we do get this bill through Parliament and flights are on the ground, that he will ignore it, and that would be a good issue on which to fight the election.
Order. Sir Edward, you should know better than that. It's topicals. You were a member of the panel as well. You went to set the example, not abuse it. Secretary of State.
Thank you, Mr. Speaker. I don't have the advantage of having listened to Lord Hoffman, but look, we don't think that the Strasbourg Court will need to intervene, given that our domestic courts will have carefully assessed whether anyone we intend to remove to Rwanda would suffer serious and irreversible harm.
SNP spokesperson Chris Stephen.
Thank you, Mr. Speaker. Unionist, of which I'm a proud member, have criticised government plans to reintroduce employment tribunal fees as the only people that would benefit from their reintroduction are unscrupulous bosses, and the Resolution Foundation found that the lowest paid workers were least likely to bring a claim. So how can the Justice Secretary defend plans to reintroduce employment tribunal fees that will disproportionately affect those on low wages and present an obstacle to justice for those that need it most?
Thank you, Mr. Speaker. The £55 claim issue fee is entirely modest and completely different from the previous fee scheme.
Exactly.
So I simply don't accept the characterisation that the honourable gentleman has said, and so I'm quite happy to defend that the small and reasonable fee is a necessary step to help defray the costs of our system.
Henry Smith.
Thank you, Mr. Speaker. What percentage of the backlog in Crown Court cases are due to foreign national offenders, and what has been done to reduce that?
Data on foreign national offenders is collected at the point when an individual becomes an offender, in other words, at the point of conviction. But in addition, the MOJ records the numbers in custody awaiting trial who are FNOs, and that stands at approximately 3,300. In terms of driving the figures down, the Home Office is working to increase take-up of conditional cautions, which lead to FNOs being expelled from the UK in place of prosecution in appropriate cases.
Ola Barker.
Thank you, Mr. Speaker. The Vagrancy Act of 1824 is 200 years old this year. Yes, it was supposedly repealed in 2022, but remains in force. The Criminal Justice Bill, unamended, represents a genuine danger for rough sleepers everywhere. When will the benches opposite stop this madness, and when will we see the 200-year-old piece of legislation off the books?
Well, I thank the Honourable Lady for her question. The Criminal Justice Bill is dealing with the repeal provisions of the Vagrancy Act, and we are bringing this back at report stage with more on rough sleeping.
Duncan Baker.
Thank you, Mr. Speaker. Now, I welcome the fact we've got these 20 Nightingale courtrooms that have been set up around the country to boost capacity, but none of them appear to be in the east of England. I know we're all well behaved in the east, but have we been forgotten about?
I can reassure my honourable friend that we would not dream of forgetting about it. Certainly, we have seen an increase, particularly on send, of over 300% of receipts, and that's why, with the increased judges and panel members, we are seeing the record numbers, or an increased level of disposals by 37% this year. We are trying to address the issue of send with the DFE. If my honourable friend thinks there is a problem in this area, I'm more than happy to meet to discuss it.
Yeah. Justin Mathers.
Thank you, Mr. Speaker. I've heard the Minister defend the reintroduction of employment tribunal fees, but the last time they came in from this government, there was a 70% drop in applications. How many people will be denied access to justice this time?
Minister.
Mr. Speaker, I have to say that the Honourable Gentleman is comparing apples and oranges. The two fees are completely different in terms of quantum. A £55 claim issue fee is a small contribution towards the tribunals that cost us £80 million a year to run. I don't think that's unreasonable.
This week we celebrate the 5th anniversary of my Civil Partnerships, Marriages and Deaths Act completing its parliamentary stages, but also the 5th anniversary of no action by the government enforcing Clause 4, giving coroners the power to investigate stillbirths. There has been some progress. On the 8th of December, 56 weeks later, they produced the results from the consultation, but no government response. When are we going to have a government response? And what is the government's problem with getting on with something it's overwhelmingly supporting?
Minister.
Mr. Speaker, I appreciate my honourable friend is increasingly agitated about the implementation of his aspects of the bill. However, the consultation was not conclusive, and the actual landscape regarding stillbirths has changed, and those issues have to be addressed if the bill is going to be introduced correctly.
Jasmine Qureshi.
Oh, sorry, Mr. Speaker, I didn't hear you. According to a report by the National Audit Office last week, housing legal aid is out of reach for many people who are struggling to keep a roof over their head. In recent weeks, I've had countless people who are facing the threat of evictions and repossessions contact me for help. With the cost of living crisis and rising interest rates, it's critical that people are able to access legal help for their housing issues. So what is the Minister doing to ensure that housing legal aid is available to those who cannot afford legal help?
Minister.
Mr. Speaker, what we're doing is investing an additional £10 million to make sure that legal aid is available for exactly those problems.
Bob Blackman.
Speaker, under the Homelessness Reduction Act 2017, it is a solemn duty of prison governors to prepare ex-offenders for life outside prison. Despite the fact we're now 7 years on from that duty, they are still not doing what they're required to do. We want to see reoffending ended, but if people are prepared for when they leave prison properly, then we increase the chances of preventing them from reoffending. What action is my right honourable friend taking?
Go on.
Well, my honourable friend has done spectacular work on this, and HMPPS published a policy framework setting out the steps that prisons and probation must take to meet their duty to refer someone who's at risk of homelessness. I was reading it this morning. It contains template referral forms and many other aids to be filled out at prescribed points in the prisoner journey. Governors are now held to account, as he rightly indicates, on their record of preparing prisoners for life post-release, which is why I'm able to say that in 2022-23, 86% of prisoners were accommodated on the first night of release, and that's up from 80% in 2019.
Can I just say to Justice Secretary, I know it was on the order paper before, but if you could shorten the answer to ensure that everybody else can get on top of it, it would help me and help others. Rachael Maskell.
Thank you, Mr. Speaker. Last week I visited IDAS, an outstanding organisation supporting survivors of domestic and sexual violence. They highlighted how the fear of a parent having their children removed is preventing victims presenting a case in full and preventing justice. How will the Minister ensure that the power imbalances in the family courts are addressed?
Minister.
Well, I'm grateful for the Honourable Lady's question. She'll know how much we're doing in victim support, particularly where it's a sexual or domestic abuse. I'd like to speak to her specifically about this issue and about parental responsibility in the family court. So I think if she could write to my office after this session, I think we should have a meeting.
Alberta Costa.
Thank you, Mr Speaker. Last week, Colin Pitchfork, the double child rapist and murderer, successfully applied for reconsideration of the parole board hearing decision not to release him on the grounds that it was irrational. I've issued a survey across my South Leicestershire constituency on parole board reform. Will the Secretary of State meet with me urgently to discuss the parole board rules as amended 2019?
I certainly will meet with him. He has been assiduous for many years now in raising this matter on behalf of his constituents. The parole board do an exceptionally good job. There are two cases where it appears to have been decisions overturned because they're irrational, and that's why I'm meeting the parole board tomorrow.
John Cryer.
Thank you, Mr Speaker. Earlier on, the Justice Secretary mentioned the introduction of a duty of candour which he imposed on the police. Has he considered legislating to introduce the same for all public bodies?
Yeah. Well, I mean, I can say that also we want to extend it so that it applies in healthcare settings as well, because what we don't want is health professionals closing ranks when something goes wrong. But it's important to note that since Hillsborough, there have been so many changes, including with the Inquiries Act and so on, which means there can be criminal liability for those who don't do what he and I must think is a matter of common sense, tell the truth. Siobhan Bailey.
Mr Speaker, wedding experts Hitched are saying that independent celebrants are the biggest trend for couples getting married this year, and with the church, registrars and humanists all also providing additional options, I think it's about time we update the marriage laws, which are from 1836. Will the government now publish a substantive response to the Law Commission's 2022 report on wedding reform?
Minister.
Mr Speaker, as someone who benefited from the last wedding reform of equal marriage, I can say that this government is entirely committed to ensuring that we report as fast as possible on the Law Commission's review, and if my honourable friend would like to meet my noble friend Lord Bellamy to discuss it further, we can make that happen.
Alison Thewlis.
Thank you, Mr Speaker. The backlog of asylum and immigration tribunal cases has soared from 35,400 to 41,500 in a month, a result no doubt of the Home Office pushing through decisions at the end of last year to clear their previous backlog. What's the Minister doing to tackle this new backlog they've created?
No. What we're doing, Mr Speaker, is we're increasing fees for legal aid practitioners, and what we've seen is a massive increase in cases going through the system, and that's why we're investing to make sure that legal representation is available.
Greg Smith.
Thank you, Mr Speaker. Given existing Buckinghamshire prisons can't recruit to staffing vacancies, where does the Ministry of Justice think it's going to magic up staff and prison officers for the mega prison that they now have planning permission for in my constituency?
Well, I'm grateful to my honourable friend, and he is a champion for his constituents. While we may disagree on this issue, I know he speaks for a lot of his constituents and does so vocally in this House. We've highlighted the 1,400 increase in prison officers. We are confident we can staff all of these new prisons and that they are necessary to meet our obligations.
Barry Sherman.
Mr Speaker, what can I do to change the Secretary of State's view on joint enterprise? Has he read Lord Finkelstein's recent very good article in The Times? Please, Minister, have an open mind, look at it again. There are 1,000 young men in prison on long sentences.
Joint enterprise is there to ensure that those who act as the burglary lookout, those who provide the weapon in the murder, those who drive the getaway vehicle do not escape for the consequences of their crimes, crimes which shatter lives. It is already the case, in the case of Joji, that the person must have helped or encouraged the commission of the offence and intended to do so. If it's the Labour Party position that people like that should escape culpability, they should say so. Our advice on this part of the side of the House is clear. Don't commit crime.
Right, that completes Justice Questions.